In Unit 2, we are going to discuss about the needs of public interest litigation. Before discussing about the needs for public interest lawyering and litigation, we must know about the basic rights. Public interest litigation can be filed when these rights are violated. Now let us see the rights which are guaranteed by the international documents, including International Covenant on Civil and Political Rights, International Covenant on Socio-Economic and Cultural Rights, CEDAW, that means Convention on Elimination of Discrimination Against Women, Child Right Convention, etc. These rights include right to life, freedom from torture, right not to be enslaved, right to liberty and security of person, right of detainees, right to a fair trial, equal right before courts and tribunals, right to recognition as a person before the court of law, freedom from arbitrary and unlawful arrest, right to hold opinions about interference, right of peaceful assembly, right to speech, right to expression, right to religious identity, right to marry, children's right, right to political participation, minority rights, right to self-determination, equal rights between men and women, right to work, equal pay for equal work, right to just and favorable condition of work, right to social security and social insurance, right to maternity leave, maternity benefit, right to an adequate standard of living, which includes adequate food, adequate clothing, and right to shelter, right to health, right to medical assistance, right to legal assistance, and right to culture, and get the benefit from scientific progress. These rights have also been ensured to the citizens of India through Constitution, especially through fundamental rights. There are 6 fundamental rights which give us the rights. For example, right to equality, which further includes equality before law, no discrimination on the basis of religion, race, caste, sex or place of birth, equality of opportunity to all citizens in matters of public employment, abolition of untouchability, abolition of title, right to freedom, which includes freedom of speech and expression, freedom to assemble peacefully and without arms, freedom to form association and unions, freedom to move freely within the country, freedom to reside in any part of the country, freedom to practice any profession and to carry on any occupation, freedom to profess any religion, and right to freedom has also ensured through other provisions, including right to life, right against arbitrary arrest and detention, protection, right to education, etc. Cultural and education rights, which may further include protection of interests of minorities, rights of minorities to establish and administer educational institutions, and right to constitutional remedies through writs under Article 32 and 226. Along with these rights, the Constitution has also ensured certain duties. Violation of the rights may happen when these duties are not respected and there is a gross violation of the rights not only by individuals but also by the state parties. It needs to be understood that public interest litigation can be filed for gross violation of rights, rights of socio-economically backward people, weaker sections of the society, and also for violating environmental issues. While Part 3 of the Constitution gives us fundamental rights, Part 4 of the Constitution speaks about directive principles of state policy. The provisions contained in this part cannot be enforced by any court of law, but these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Public interest litigation and lawyering may play crucial role in implementation of these directive principles. The directive principles of the state policy may include the followings: the duty of the state to secure social order for the promotion and welfare of the people at large. The state shall in particular direct its policy towards securing equality, ensuring right to an adequate means of livelihood, equal distribution of natural wealth, etc., for ensuring equal justice to all, for ensuring right to education for children, for ensuring living wages for workers, for ensuring participation of workers to management of industries, to provide for free and compulsory education for children below 14 years of age, and also to ensure protection and improvement of environment and safeguarding natural wealth. These directive principles have been used in creating laws and rules on the basis of guidelines provided by the courts. A very good example of this is Vishakha versus State of Rajasthan, which motivated creation of law for prohibition of sexual harassment of women at workplace. Now, let us discuss about the position of socio-economically backward people, and let us understand why public interest litigation and lawyering is needed for these classes of people. Articles 16 and 17 of the Constitution speak about special provision for women, children and minority people. Part 16 of the Constitution speaks about special provision relating to certain classes. These classes include scheduled castes and scheduled tribes, and also certain people who have been grossly victimized during the colonial era and also who are being discriminated post-independence. Now let us consider the issues of certain people as we have just discussed and see how public interest litigation have helped the causes of these people. First, let us take up the issue of bonded labor. What is bonded labor? To understand this concept, we need to understand three factors. Number one, bonded debt. Bonded debt means an advance obtained or presumed to have been obtained by a bonded labor under or in pursuance of the bonded labor system. What is bonded labor? Bonded labor actually means any labor or service rendered under the bonded labor system. And who is a bonded laborer? Bonded laborer is one who incurs or who is presumed to have incurred bonded debt, because of which he has been trapped within the system of bonded labor. Now, there are various forms of bonded labor. These forms of bonded labor can be seen in the fields of domestic work, agricultural unit, begging, also in construction unit, manufacturing unit. Bonded labor system can also be seen for child laborers and also in cases of prostitution. Now let us understand who may be the victims of bonded labor. They can be children, they can be migrant workers, women, they can be indigenous people, they can be economically and socially backward people who may not have proper fund for education or who may not be aware of their rights, and they can be also differently abled persons who may not be able to approach the courts or who may not be knowing about their rights and may have been trapped in the bonded labor system. Even though we have statutory laws for prohibiting bonded labor, that is, the Bonded Labor System Abolition Act 1976, it has been noted in different cases that bonded labor is still rampant in our society. Let us see some of the cases. In the case of People's Union for Democratic Rights versus Union of India, the court observed that denial of minimum wages for bonded labor is actually a violation of Article 21. This case involved non-payment of wages in the Asiad villages. The court also opined that force must also mean physical force as well as economic and other compulsions. In the case of Bandhua Mukti Morcha versus Union of India, the court also observed that bonded labor system is also there in the stone quarries. The Supreme Court in this case gave direction for setting up commission for inspection and vigilance over implementation of laws and punishment. Again, in the case of Dina versus Union of India, the Supreme Court held that reformation in prison administration should not be considered as bonded labour. The court held that prisoners must also be paid a minimum wage for the labour in the prison system. Even if it is for reason of reform, no one should be deprived of his right under Article 21. Now, let us consider the causes of maternity benefit. As we have discussed, maternity benefit is one of the prime rights that has been given to women at large. Maternity benefit, or the concept of maternity benefit, stems from the right to equality under Article 14. We have got a provision, that is Maternity Benefit Act 1961, which was very recently amended in 2017. It has been held by the courts in Rama Pandya versus Union of India that the concept of maternity benefit and maternity leave should be expanded for biological parents, non-biological parents, including those who are availing surrogacy services. Now, let us consider the rights of the hawkers. As we know that the hawkers may not have stable shops, but in this case, that is in the case of Olga Tellis versus Bombay Municipal Corporation, it was held by the court that mercilessly eviction of hawkers is actually violation of human rights. The court also held that alternative arrangement should be done and demarcation of hawking and non-hawking zones should be taken up by the states as a duty towards people who are having the profession of hawkering. Now, let us consider about the cases of rights of slum dwellers. It has been held by the courts in number of cases that slum dwellers must be allotted housings. In the case of Adan Muhammad Khan, Aliyar Khan and others versus State of Gujarat, it was held that slum dwellers cannot restrict eviction when allotment of alternative residence has been given to them. Now let us consider about the cases of environment pollution and the need for pill. In M. Periyasamy versus State of Tamil Nadu, before the Madurai bench of the Madras High Court, the court observed that sand quarrying in the river banks causes grave harm to the ecological balance. It was held that sand quarrying is to be prohibited in the river banks, refilling of the pits should be done, and establishment of state-level monitoring committee should be done to monitor ecological balance. In the case of State of Tamil Nadu versus Hindstone, the Supreme Court also observed about the doctrine of public trust. The Supreme Court stated that the natural resources are not only meant for the present generation but should be preserved for the posterity. The government and the present generation acts as the trustees for the future generation. This means that the natural wealth should not be wasted by one generation and it should be preserved for our next generations as well. And this has given rise to the need of filing bill for preserving the natural wealth, the natural environment, and also mountains, lakes and rivers. Also, in the case of rural litigation and entitlement Kendra versus State of UP, the court observed that everybody has got right to be free from pollution from mining. One of the landmark cases of pill in environmental issue is MC Mehta versus Union of India, where the Supreme Court observed that prevention of Ganga water pollution is the need of the day. In this case, the Supreme Court directed to plan for sewage line along the Ganga river and also to shift the dairies to avoid wastage from the tanneries to be flown into the river Ganga. It also directed to prevent floating of dead bodies in the Ganga river. Also, it directed the states to narrow down granting of the license to new industries. Now, let us consider about the pills for the cause of women. Why specifically pill for women? Because they can be the victims of social oppression, they can be the victims of social evil, they may lack education, they may lack economic independence, and they can be easy target of sexual violation. Let us now discuss about certain pills which were filed for the cause of rights of women. In the case of Vikram Singh Dev Tomar versus State of Bihar, the court observed that there was a gross violation of rights for women and there was a pathetic living condition for women in the shelter homes. The court directed that right to life is coupled with human dignity. Therefore, there should be proper facilities in all shelter homes which are meant for women. Now let us consider about certain cases of pill which were filed for rape or sexual violence against women. Delhi Domestic Women Workers Forum versus Union of India is one such landmark cases where it was held that rape of domestic workers in train by army personnel is a gross violation of human right. Here, the court held that lawyers must be provided by the Legal Services Authority for helping the victim. Also, it noticed that development of compensatory jurisprudence for rape and sexual assault victims is a must for every society. It also discussed about interim compensation mechanism for rape or sexual assault victims. Now, let us consider about the landmark case of Vishakha versus State of Rajasthan, which motivated for the development of workplace harassment policies, which again created the landmark law, that is Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. There is one more landmark case that we need to discuss when we are discussing about pills for women's right. It is Gaurav Jain versus Union of India, in which case the court observed that the inherent dignity of the prostitutes must be respected. The schools should not discriminate the children of prostitutes basing on the profession of their parents, and the court also directed the states to make some self-employment schemes. The court also opined that Devdasi system must not be allowed. Further, in Prattle Kumar Sinha versus State of Odisha, the court observed that letter petitions may be accepted for the cause of women, especially for women who are handicapped like the blind girls who were staying in shelter home. However, the court also observed that news media reports cannot be taken as the basis for filing any public interest litigation. These reports must be verified before accepting the litigations as public interest litigations. Now, another landmark case that can be discussed here is Chairman Railway Board versus Chandrima Das. The questions that arose in this case was, can a Bangladeshi woman be represented through pill? Can she get compensation from the government for rape which happened to her in the railway station premises? Can this be treated as violation of fundamental rights under Article 21? The court answered it affirmatively because rape of women in the railway station premises is actually violation of human rights. Again, the court also considered cases which came with dowry harassment causes. For example, Joint Women's Program versus State of Rajasthan. Here, the court observed that direction for investigation of unnatural death should be given to the SP to prevent dowry harassment and death related to dowry harassment. The court also observed that dowry harassment cell should be constructed and appointment of 2 activists in dowry harassment cell should be done. Further, the court also observed that Sati Pratha is actually a social evil against women. So, in the case of All India Democratic Women's Association and Janwadi Samiti versus Union of India, it was observed by the court any religious celebration which glorifies sati must be prevented. Money collected for such kinds of festivals should be used only for temple maintenance and not for glorifying any sati pratha. Now, let us consider the cases of child rights. As we know, the Indian Constitution provides several rights for children. For example, Article 39F, which speaks about development of children in a healthy manner. For example, Article 24, which prohibits employment of children in hazardous work condition. Article 21A, which speaks about right to education as a fundamental right, and again Article 45, which is a directive principle of state policy, whereby the state is directed to ensure free education for children under 14 years of age. Now let us consider about certain pill cases which were taken up by the courts for ensuring child labour, especially child labour in hazardous condition. People's Union for Democratic Rights versus Union of India 1983 is one such landmark case where the court held that construction work is hazardous and therefore no child can be employed in any construction site. As we have seen, child right also includes healthy development of the child. We must also consider about pill cases which were filed for regulating adoption. Trafficking in the name of adoption may happen. Adoption of Indian children by foreign nationals may also happen, and it can happen through the NGOs who are dealing with adoption. In Lakshmikant Pandey versus Union of India 1984, the Supreme Court observed that social organizations and NGOs are trafficking the children in the name of adoption to not only domestic places but also to foreign lands. It was held that the absence of proper provisions from Guardians and Wards Act 1860 must be relied upon. However, this case later motivated for creation of CARA guidelines, which is now a principle for regulating adoptions. Now let us consider about certain pill cases which were filed and which gave positive results for regulating conditions of children in adult jail. In Kamala Devi Chattopadhyay versus State of Punjab 1985, a letter petition was filed which was in the nature of pill, and this was filed for releasing the children who were detained during the Operation Blue. Direction was given for release of the children and also for conducting procedural inquiry in this case. Again, in the case of Sheila versus Union of India 1986, release of children detained in the adult prisons was taken over by the Supreme Court. It was held that development of healthy rehabilitation of juvenile offenders is the need of the day, and this may also protect the child rights. Again, there were several pill cases that were filed to prevent child marriages. For example, let us consider the case of Susheela Gothala versus State of Rajasthan 1995. In this case, it was held that prevention of child marriages on specific occasions like Akatij must be prevented. Finally, the court also observed that constitution of district, block or village level committees for preventing child marriages is the need of the day. Now let us discuss about the scope of speedy trial and speedy access to justice. There can be two-phased scope. For example, for the pre-trial detainees as well as for the post-judgment detainees. In Husainara Khatun versus State of Bihar, this public interest litigation was taken up because the court observed that speedy trial is a part of liberal extension of Article 21. Now let us discuss about the right to speedy trial and why public interest litigation is needed for the under trial prisoners or detainees. What is right to speedy trial? Actually, the concept emerged from 6th Amendment to the US Constitution. The concept of speedy trial actually includes right to speedy trial, right to legal counseling, impartial jury, right to know about the charges, and right to know about the accuser. Reasons given by the US court for ensuring right to speedy trial are there can be loss of witness by the time, or there can be blurring of memories of available witnesses because of passage of time. It also involves social interests, especially for lost childhood. However, right to speedy trial is not recognized through focused constitutional provisions in the Indian Constitution. Now, there can be two types of trials, civil trial and criminal trials. Most of the PIL cases have been filed for criminal trials. Gradually, this right to speedy trial has been evolved through statutory rights, especially section 167 of the CRPC, which speaks about the time limit for finishing trials. For example, 90 days where the investigation relates to an offence punishable with death, imprisonment for life or imprisonment for a term not less than 10 years. However, it has been seen in many cases that in spite of such kinds of regulations or in spite of the understanding by the court, speedy trial has been denied to many under trial prisoners. For example, let us see the case of Rudalsa versus State of Bihar, where the concerned person was detained in the prison for 20 years even after the judgment for release was given to the person concerned. Now, reasons for the court for interference may escalate because there can be loss of childhood, there can be suppression of and oppression of women within the prison system, there can be enormous growth of victimization of bonded laborer, especially when it is concerned with speedy trial for bonded laborers. There can be rapid rise of corruption if the cases are not taken up properly, and also there can be the issue of victim justice also. Now, let us discuss about compensatory jurisprudence and need for PIL. Now, what is compensatory jurisprudence? Under the law of torts, the victim can claim compensation for the injury done to him or her. Now, compensation can be paid either in the civil cases or also in the criminal cases. Most of the PIL cases which have been filed for compensatory jurisprudence comes from the section of criminal law. Compensatory jurisprudence under international covenants can also be analyzed in these cases. It has been seen that international covenants such as civil and political right also recognize the right to get compensation as one of the basic human rights. Compensation can be provided by the state for any sort of right violation. Compensation can also be given by the private parties. In our laws, section 357A of the CRPC speaks about compensation for criminal injury. It also provides some kinds of schedules which can be used by the courts of law for providing compensation for various sorts of right abuse as well as crimes that may have happened to the victims. Now, let us consider about certain constitutional provisions which speak about compensation for state action. Article 32 speaks about remedies for enforcement of rights conferred by the Constitution. It states the right to move the Supreme Court by appropriate proceeding for the enforcement of the rights conferred by this part is guaranteed. Further, it states the Supreme Court shall have the power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto or certiorari, whichever may be appropriate for the enforcement of any rights conferred by this court. This actually ensures, or this actually means that compensation can be provided by the state for any wrong action which has been done by the state. Now, let us discuss about certain cases where such kinds of failure of duties on the part of the state have been taken over by the courts and compensation has been provided by the courts. Compensation has been provided by the states through court procedure. In Kethry versus State of Bihar, the case involved about custodial torture. The court observed that in Bhagalpur, certain prisoners were blinded by the Police Act. the court also ordered for compensation to be paid by the state for these victims. Now let us consider the case of Rudal Shah versus State of Bihar again. Here again, the court ordered for compensation to be paid for the detention of the prisoner even after the release order was passed by the court. Again, in the case of Sebastian Hungary versus Union of India, it was observed that when the state failed to answer habeas corpus petition for reporting about the missing man who was working in the army, the family was liable to get compensation. Again, in the case of Saheli versus Commissioner of Police, the court held that the state is bound to pay compensation for mercilessly beating and killing a 9-year-old boy for eviction of women. Again, the case of State of Maharashtra versus Patel is also another landmark case which spoke about police atrocities against right to reputation. In this case, the concerned person was handcuffed in public. The court ordered the sub-inspector to pay compensation to the victim, and also it was ordered that mark should be made in his service record. Now, let us discuss about cases of custodial death and compensation. One such case is Nilabati Behra versus State of Odisha, where the court ordered for payment of compensation through a letter petition for habeas corpus, and it was found that the concerned person, that is a 22-year-old youth, died in custody. The court ordered for payment of compensation to the family. Also, compensatory jurisprudence can also extend for riot victims. One of the landmark cases is Gagan versus State of Gujarat, which happened in 2008. The court also directed that the defendant failed the riot victims during the Gujarat riot. Further, additional relief and rehabilitation should be provided on the compassionate ground, and compensation should also be paid for the riot victims for failure of the state duties.